Yes. Dr. Abe, wrapping up, you know that the CI 127 clearly stipulates that results that have been declared by the regional election officers must be gazetted until those results are gazetted. It doesn't hold. And it must be done within 21 days. So to go to court before the results are gazetted, it's also contrary to, it's alien to what CI 127 states, because we are not even out of the 21 days.
Okay.
Which is why, for me, I feel that the Electoral Commission still has that mandate.
No, but when you say they have a mandate, that mandate must be supported by law. Because you read the 127 and talked about, you identify what you consider a gray area.
Yes.
You understand me? So let's assume that is a gray area. The Electoral Commission then cannot assume.
Yes, but you see,
and I'm sure that is what has led to the NDC going to court on that fight.
Yes, but all of these results have not been gazetted. It's declared but not gazetted.
Yeah, the Gazette only tells you
that this is
that if you want to go to court, you can only go to court when this has been done. Exactly. It doesn't take away your right to go to court.
Of course, it does not.
In any case, we saw at Scene North, an MP was in court, was in Parliament. He was sworn in, he sat there. The Supreme Court sacked him.
Yes, so because then they're saying
the EC should go and say the ones that they've declared, let it so be.
And go and challenge it in court.
We should have a stage where the EC gazettes these results.
Okay.
But the EC cannot gazette the results because there are reports that have come from the regional officers that they were forced to declare the results in favor of Green. And so because of that, the EC says that then they either need to recollate, retabulate, put everything together, and then declare the results again. Having further on done that, then now the EC can go on to gazette the results. If the EC gazettes the results,
so in Techiman South,
contend that.
In Techiman South, when the NDC protested, why did the EC not take that same position? The position is taken today. Why didn't it take that position when the Honorable Haruna Idrisu, and by the way, sad news is that the Honorable Haruna Idrisu, former minority leader, former minister, has lost his mother this very morning in Tamale. So our commiserations to you, the Honorable Haruna Idrisu, on the loss, the demise of your mother this morning in Tamale.
Our deepest condolences to respected Honorable Haruna Idrisu. I have a lot of love for him, and I'm sure that at his age, his mother would also be very old. So it will be a good life lived, and I'm sure that should be buried immediately. But we'll come for the 40 days Adwa. I don't know whether you add yours before I go to the topic.
Yeah, our condolences to our leader. It's always sad to lose a mother, but we pray that Allah will strengthen him and the family during this period.
Okay. So now, Dr. Abe, so maybe I will need a reminder of whether the Techiman was gazetted or not. You understand? Because the CI is very clear.
No, it was eventually gazetted.
It was eventually gazetted. Good. So at this stage, the contention really, and I can appreciate that, yes, people have their right to go to court, but at this stage, the issues that are at stake is that there were returning officers for the parliamentary who said, based on the pink sheets, based on the number of people that had voted.
So I have a very senior lawyer who sends me this one. He says that coercion and duress are issues of evidence to be established in courts. Nobody has the power or right to determine that. It's an issue of fact to be established in court by leading credible evidence. In short, there are factual issues which have to be established by credible and cogent evidence in a court of competent jurisdiction. What if the NDC also raises those issues for constituencies that they also lost? Would that be a basis for the EC to say that? So he says that coercion and duress are issues of evidence to be established in court. So if you go to court and those allegations have credibility, it will be established beyond reasonable doubt in court. And on the basis of that, after weighing the evidence and putting weight on those evidence, the judge will then take a decision. But it will not lie within the power of the EC to make that kind of determination.
It does not lie in the hands of the EC to determine whether the results were.
No, I'm saying that an officer says
yes,
I was coerced.
Okay.
Another party says it's not true. You were not coerced.
Okay.
The forum for determining that is not the EC. That's the point I'm making. It's not the EC. We all agree, and that is why the law makes provision for that. So let's all go to court. I'm saying that, look, for me, I'm saying that even as in North, the court was able to stop the person at a point in time from even going to parliament. Yeah. The court was able to annul whatever happened. The court was able to direct for the EC to go and hold a by-election. And we all had the patience and everything, whether we agreed or disagreed, to follow that as due process. So if something has gone on, a person is claiming that ABCD happened, the right forum is to go to the court, lead the evidence, let the court establish that, and take a decision. Why? And that's where my issue is. It appears that all of a sudden we are court averse.
But also, how many of the presiding officers are saying they were under duress? Apart from the one, I think in Tema Central. You know. So I think that one is a very minimal or a very simple issue. The majority that are being discussed, for me, I think my take is that once that the returning officers have declared, that one should remain so. But it's up to the EC to, if not, and any other group of persons have any other, they have their pink sheets to prove otherwise. I think that one too, then it's within the preview of the EC to be.
So are we saying that tomorrow, if there is an election somewhere, and then a presiding officer writes to the Electoral Commission and say that I was forced
to declare,
I was threatened, my life, I felt threatened, that would be a basis for the EC to say that it is not going to uphold that declaration. Would that be a basis?
No, that shouldn't.
We might get into the realm of absurdity.
Absolutely, but you see, though, one of the things that we also must be minded of is that the regional officers, the regional election officers, must also ensure that if you are coerced, don't declare.
Yes, I don't have that right. I don't have a problem with that.
You also have the right to hold.
I don't have a problem. I don't have a problem. I don't have a problem with that. But I'm saying that when the declaration has been made, fortunately, the court provides. You understand me? In that same note, this is somebody who had been cleared by the Electoral Commission. But yet we said that, look, the Electoral Commission's clearing of you, the Electoral Commission even heard the issue. There was a protest, a petition to the Electoral Commission by aggrieved persons. The Electoral Commission heard those aggrieved persons, and on the basis of that, cleared the man to run. Yet, when it came to that issue, our position was that it doesn't lie with the Electoral Commission. It's an issue for the court to decide. So the Electoral Commission's hearing of the petition, listening to the issues, and approving of the gentleman, what's his name? Question. Yes, question to run, really was neither here nor there. We ousted their jurisdiction in that particular matter. That's what happened.
A determination of the court.
Yes.
Clearly, a determination of the court. Clearly.